ideological inclinations, biases, and so forth. And then the second part is discussed here. The second aspect of the final frontier is the independence of an individual judge from the undue pressures of his peers and from unnecessary or unwarranted controls of his institution. There is no doubt that in his capacity as a judge, a person performing judicial functions is necessarily a part of his institution, i.e. the judiciary, and ordinarily his functioning is to be in line with the overall policy and scheme of the institution. However, the problem comes when the institution's independence is itself under cloud because of extraneous factors, and an individual judge starts abdicating his decision-making before the dictates of the institution, or conversely, when the institution starts excluding an individual judge from decision-making in sensitive matters because that judge is not likely to toe the line of the institution. Both these factors, which may be unthinkable in the civilized world, are unfortunately real possibilities in some other parts of the world and completely undermine the notions of independence of judiciary. Apart from the above, concentration of powers in the hands of the head of a judicial institution regarding constitution of benches, allocation and distribution of cases amongst benches, attaching priority to different kinds of cases, and geographic transfer of judges is an issue which has raised eyebrows in the past and can also resurface in the future. A possible misuse of such powers by the head of a judicial institution can effectively render the independence of an individual judge to be of no practical utility or benefits to the citizens at large. Such a threat to independence of judiciary has its origins within the judiciary itself, and any degree of independence of judiciary painstakingly achieved through all the other stages mentioned above can effectively be neutralized through machinations from within the judiciary itself. In this context, I feel that independence from judiciary in the above mentioned areas may be a sine qua non for reaching the final frontier of independence of judiciary. Now, of course, the author of this article eventually adorned the office of the Chief Justice of Pakistan, but nonetheless, for whatsoever reasons, no structural change could be brought about to achieve this final frontier of judicial independence. Now, this concern about the untrammeled powers, the untrammeled discretion of Chief Justices is not unique to Justice Khosa. Another future Chief Justice has also...
Mr. Salahuddin, it is a person-specific argument which you are raising before us?
Not at all, sir. What I am saying is that this concern has been raised by multiple of your lordships.
The issue before us, to come to that.
Yes, the issue that I am coming to, sir, is that there have been multiple concerns expressed by the judiciary itself about the concentration of powers in the office of the Chief Justice and the potential for abuse of those powers and the perception that it creates in the general public. Now, those are exactly the issues when Parliament is being accused of acting with...
The matter relates to the institution.
Yes, sir.
Please, we are sitting to hear you.
Let's go for let's look at the law. Your point is taken. You feel that there are voices coming from the bench. Fine, point taken.
Mr. Salahuddin, whatever you are saying assumes competence. That's the key points over there.
I will come to both.
All of this may be right, all of this may be wrong, some of it may be right, some of it may be wrong. Tell us about competence.
I will address the issue of competence if your lordships will allow me.
किसी का अपना view है होगा.
Sir, bilkul. I will cite, not read from them, but I will cite the different judgments in which, at least I think, if I'm counting correctly, 10 members of this present bench have raised concerns about the concentration of powers in the office of the Chief Justice. And my submission would be that that in itself dispels any argument of malfidation.
Does that in itself confer legislative
competence? No, sir,
on
it does not. It does not, and I will deal with those independently. I'm just completing this, sir.
Kindly tell us what you say about who is Parliament the master of the roster?
Yes, yes,
As a matter of principle.
If you're, I will come to that,
मुस्तफ़ा
sir.
ये ना, ये
I will come to that,
किसी
sir.
की कोई view है, किसी की क्या view है?
Yes, I will come to that. I just want to quickly cite those judgments, sir. PLD 2019, Supreme Court, page 183.
183.
Yes, sir. PLD 2021.
What proposition is this?
Sir, these are all judgments and dissenting notes and additional notes in which different judges of this court have on various occasions
I think
raised.
you should be a bit careful. With all due respect, I don't
Ji.
want to stop you from making your submissions, but you know you're treading on relatively thin ice here, in the sense that if you're quoting a retired judge, that's one thing. But if you're quoting sitting judges in this particular context, before a full court, when the very competency of Parliament is under challenge, I think it's better for you to just focus on. I hope you understood what I'm saying. I don't want to say anything
I'm
further.
not, and that's why I'm just
It's not,
placing
please don't.
I would like to hear what you're
Views have
saying.
been expressed, they have been
I would
expressed.
like to hear what
those
you're saying.
judgments before your lordships. I'm not
Citation
you cite them?
any extraneous
उसको
material. I'm
जरा
not-
मशीन
Salahuddin,
Can you please cite them? Please cite
citation
them.
बताइए,
Sir,
citation.
PLD 2019, Supreme Court 183. Then PLD 2021, Supreme Court 446. There is a dissenting note in that.
कोई relevant pages आप नहीं बता रहे हमें. Relevant pages.
Sir, I'll dig them out then, sir. PLD 2021, Supreme Court 446 में, sir, it is.
इसका टाइटल केस का क्या है?
Sir, ये PM's discretionary fund है. The earlier one is.
चलो लिख के दे देंगे pages.
जी, मैं दे देता हूँ,
आप
sir.
citations
जी,
दे.
मैं दे देता हूँ, sir. Then there is PLD 2023, Supreme Court, page 306. There is PLD 2022, Supreme Court, page 3006.
2023 Supreme
20,
Court.
PLD 2022, Supreme Court 306.
23 का भी आपने बताया, ये
जी,
22 का भी
23
same page.
जी, नहीं, PLD 2023, Supreme Court 306 and PLD 2022, Supreme Court 306.
दोनों, both have the same
जी, sir.
page.
And उसमें this second one, sir, जो 2022 का है, that is Suomoto case number 4 of 2021. And in
चलिए वो
that,
देख लेंगे ना. Let's just
I
cite
rely
them.
on paras 53 and 56.
53.
अभी citations ही दे दें.
That's right. That's it.
And sir, there is SMC number 1 of 2023. There are 3,
Reported or not reported?
sir, not reported as yet.
SMC number?
1 of 2023.
ठीक.
And SMC number 4 of 2022. Now, in addition to that, sir, the bar councils and bar associations have obviously been passing resolutions on this issue for
With
almost
all
a
due
decade.
respect, again, to the bars
Yes.
and councils.
Main question
What does
is-
that have to do with
My lord,
competence?
there is.
I mean, are we supposed to be swayed by, with all due respect to what, those are extra judicial
Not at all,
statements.
not at all.
Kindly
Your
talk the
lordship-
language of the.
Your lordship will appreciate.
See,
ये
That's-
कानून की बात कीजिए, ये तो नहीं कि
Salahuddin, there are only two questions involved here.
Ji, sir.
One is who is competent, question of competency. And two, if we come to the conclusion that yes, there is competence, then you have to convince us that the law as framed is not in conflict with any provision of the Constitution. If you would kindly address these questions, I mean, most of your case would be
My lord, what
encompassed in that.
I'm grateful to your lordships. What the main challenge by the petitioners has been on two grounds. One, that it infringes, the legislation infringes the independence of judiciary. That is one completely separate issue. And the second is that that it is beyond the legislative competence of Parliament. Now, in the legislative competence issue, obviously, whether the law is an excellent law or a terrible law is irrelevant. I will gratefully adopt your Lordship's formulation on that. But as far as the challenge on the basis of independence of judiciary is concerned, the merits and substance of the law and its background is very relevant. That is why I'm briefly, I'll come to the legislative competence too. Sir, if your Lordships will see that I'm not going to go through the resolutions or anything, but they're at page 171 to 185 of that booklet.
But
And if your Lordship,
one thing, I've seen judgments of this court which have cited news reports for relying on various things, and consequences have flowed from those news reports. So I, for one, do respect what the highest bodies of lawyers have to say, whether it be the Pakistan Bar Council or the Supreme Court Bar Association, most ably represented by Mr. Abid Zubairi. So if you want to file those, I mean, I would place greater credence on them than on newspaper reports which have been taken note of and judgments passed by relying thereon. So if we keep talking about this chariot perpetually ad nauseum, the two wheels of the chariot, now let us see this chariot work.
it is, in my humble submission, is
But I
that
think
they are relevant.
I think competence of a law has never been, as far as I
I
can
certainly
recall,
want to hear a person's point of view.
is decided on the basis of newspaper reports. Those are other contexts.
Yes, legislative competence is a separate issue. I'm dealing right now with the independence of
Right now
the
you-
seeming
No,
infringement.
but independence of the judiciary itself is, if it is violated, then the law is incompetent. Competence is not just legislative competence. Competence is also competence vis-a-vis other provisions of the Constitution.
My lord,
And what the people perceive independence to be, and more so than the people, those dealing with the law, which is the legal community. So I definitely want to see the perception of independence. I mean, it may be very independent, but people may think it otherwise, and vice versa. It may not be independent, and people may think it very independent. So yes, you don't have to spend a lot of time on it. If you can just refer to them or give it to us.
They are at pages 171 to 185. And they are resolutions that what I was able to discover were only dating back till 2018, but I understand TBC has filed something going back to 10 years ago. But there is just one aspect of those resolutions that I would ask your lordships to consider. And that goes to some of the questions that have been raised. If your lordship sees that initially in all those resolutions, the request was for this court to amend the Supreme Court rules to regulate the suo motu power and to regulate the master of roster power. That was the demand for the major period. Eventually, there has been a change in the tone and direction in the last 2 or 3 years, which has then now, in the more recent resolutions, asked for Parliament itself to directly act under 175 and 191. And presumably, the change in direction was because there was no effective response from this court on its administrative side. I'll move on, sir. Now, Justice Hilali had asked 2 pertinent questions, and Mr. Zahid Ibrahim had also pointed out the need to look outside. And those 2 questions was, one, if the CJ's power to form benches and assign cases was taken away, what would be left of the CJ's office? And secondly, how the formation of benches and fixation of cases is dealt with in other countries. Now, the answer to that first question is that there are certain specific powers and rights of the Chief Justice that are enshrined in the Constitution itself. There are about 9 that I can think of. I'm not going to go through them all, but they are there in my concise statement. Apart from the ceremonial powers, there are 9 concrete powers. The power to make benches and assign cases is not a constitutional power at all. It is not mentioned anywhere in the Constitution. In 1935, in the Government of India Act, it was indeed a constitutional power of the Chief Justice. In the 1956 power, there was a direct provision in the 1935 Act. In 1956, that power was moved to the 3rd schedule of the 56th Constitution and made subject to rules, and then by virtue of Article 177 made subject to Act of Parliament.
This was
After
1962?
1956.
56.
3rd schedule में थी power that the Chief Justice may subject to rules, form benches, etc. And that was in turn subject to Article
What about
177.